Hello everyone, welcome to this video debate organized by ELSA Belgium. We're making this video debate in the framework of the publishing of our guidelines on the processing of personal data by contact tracing system in the context of COVID-19 pandemic. We are two people from ELSA Belgium advocacy team on data protection to interview our speakers. My name is William Alexandre Toublanc and my colleague is Maria Ionescu. In this video debate, we are going to focus on the challenges and main issues related to matters such as the importance and implications of consent and the meaning and reachability of anonymization. The two speakers for this debate are Daphne van der Eycken and Paul de Witt. Thank you to be here. Mrs. van der Eycken, can you briefly introduce yourself first? Mr. de Witt, can you do the same afterwards?
Sure.
Hi, everyone. Very happy to be here. So I'm Daphne van der Eycken. I am a legal researcher at CITIP. I've been working there since November last year, and I'm mainly involved in e-health and data protection.
Yeah, and from my side, my name is Pierre de Witt, and I'm working also at the K11 Center for IP and IT Law, mainly in areas related to data protection by design, a bit of algorithmic transparency and smart cities as well. Also trying to getting started with my PhD, which will also be about data protection by design from a technical and a legal perspective. So that in collaboration with the Faculty of Computer Sciences here at K11.
Okay, can you just tell us what is the CTIP, Daphne, just to introduce the center?
So the CTIP or CITIP is the Center for IT and IP Law. It is a department, a research department in Leuven, so the KUL. We handle everything that is e-health, IP, obviously. We have a new sports and AI division, so everything that is exciting in IT law, I think we try to be involved in.
All right, so we are going to go directly to the first question. So the first question is, under which circumstances should consent represent the legal basis for the processing of personal data in the context of contact tracing apps? And what about in the context of call centers as a part of the contact tracing system?
Sure, maybe Daphne, you give it a first shot and then I complete what you say. Sure.
Yes, so with regard to that question, I think that Pierre and I wanted to reiterate that you have 6 legal grounds in the GDPR. So consent, it's a common, I think, misconception that you always have to rely on consent. However, the GDPR is much more than that. You have 6 different ones. And so under which circumstances should consent represent a legal basis? I think you have to make a differentiation with regards to the contact tracing app. So you have the downloading of the app, and then you have the actual processing of it. And consent is actually not really set to be the legal ground for the processing of your data once your app is downloaded. And I think that if you want to make the big distinction of what should be under consent and what should not be under consent, would mainly be the processing for the epidemic purposes. So to actually see if there's a contact that is recorded, that should probably be under public interest or under legal obligation. Now, for both, you need a law. And then you have the additional research purposes. That's what the Belgian DPA has been saying, is that there you would need consent as a legal basis. But so I don't think that consent is the most fitting or the most appropriate legal ground here. If Pierre wants to add anything on that.
Yeah, sure. So I think, yeah, indeed, as Daphne said before, it's really important to stress the fact that consent is obviously very important in GDPR, but it's definitely far from the only lawful ground you can rely on. So mainly people have been thinking, okay, look, you really need consent in order to comply with data protection law. Well, that's very much a misconception about the regulation, to be honest. So in the context of contact tracing apps, in the context of the pandemic here, I think indeed you need to distinguish between the installation of the app, for instance, whether or not you are going to make that compulsory or mandatory for citizens. That's one question. And the other question is, okay, once you start processing the personal data for the purpose of fighting the pandemic, then you really need to have a lawful ground. And the lawful ground, as Daphne said here, is not consent. And the European Data Protection Board has not advised to use consent for the purpose of fighting the pandemic. For research purpose and additional stuff you want to do with the data, for instance, that might be the go-to lawful ground. But when it comes to really fighting the pandemic, you do have the lawful ground legal application, for instance, that is very useful. And you also have the lawful ground about public interest. So I think those ones are really, really the most important lawful grounds you can go for when it comes to fighting the pandemic. So really important to distinguish. Consent is there and is really important, but definitely far from the only thing you can rely on when you want to justify the processing of personal data.
Thank you for this answer. I would like to ask an additional question regarding consent as a legal basis for the processing of personal data for research purposes. How do you consider that this consent should be expressed in order for it to be valid? So how should it be exactly collected from the users or from the citizens?
Yeah, I can give you if you want. So you do have several components of a valid consent under the regulations. The first one is the fact that the consent, in order for it to be valid, needs to be freely given. And by freely given, if you read the soft law around the notion of consent, it says that it basically must be something that is freely given, so no coercion. There should not be any negative consequence in case you do not consent. So that's also very much related to whether or not you will make the app mandatory, for instance, because if you're facing negative consequences at work, for instance, if your workplace all of a sudden decides to roll out the obligation for you to install contact tracing apps in order to enter the work floor, that might be something very problematic. So the consent in that kind of relationship, especially when you have states, and as Daphne will probably talk about this poor imbalance between state and citizen, or poor imbalance between an employer and an employee, well, the notion of freely given is kind of difficult to achieve. That plus for me, like, of course, the major component is the fact that consent is kind of void if you do not have an informed consent. So you really need to provide the data subject with the information, otherwise he will consent to something he's probably not even aware of. So the consent means nothing in a void, in a vacuum. It really needs to be paired with the useful information for the data subject to make an informed decision. Otherwise, again, the consent will not be worth anything. That, and also you cannot consent in a blanket manner. You cannot give consent for anything and everything. So you really need to pair on top of the useful information for the data subject the specific purposes for which you will ask the consent. So if it's about fighting the pandemic, this needs to be clarified, so that's transparency, but this needs also to be very specific only for that purpose. So if you give your consent for the processing of your personal data in the context of COVID-19 fighting pandemic, for instance, that is one type of purpose, and it should be limited to that. And that's also tying to another principle, which is purpose limitation, of course. So I would say those are, for me, the three. There are other components, but the three main components are those three. Probably Daphne wants to comment about that as well, because there are more.
What I wanted to maybe add is, since you have to make the distinction between the actual downloading of the application and the processing of your personal data later on, well, it actually, in practice, I think it means that the mere fact that you download the app cannot constitute consent, because you need that transparency criterion, as Pierre has pointed out. So you actually have to know, be made aware of whatever is going to happen with your personal data. And what Pierre briefly said about the imbalance of power is indeed, since the data controller will, well, in Belgium, it's going to be Cienzano, but the European Commission, the European Data Protection Board hinted at the fact that it should be the public health authorities. So it's actually part of government. And when government is asking you to do something, well, it's kind of very hard to say that that relies on consent, that is completely freely given, because as a citizen, you usually don't really feel like you're on the same level of power, let's say, with your government. So I think that would also, to come back to the previous question, devoid the possibility of relying on real consent. So yeah, that's what I wanted to add for this.
And also unambiguous. So yeah, that's also something that is not really new with the regulation, but of course you cannot deduce consent, as Daphne said, from the circumstances of the fact. So installing the app should not
exactly.
be seen as a way of consenting, at least not under the GDPR. So you need to have like an unambiguous action, and usually no pre-ticked box, for instance, or stuff like that. You really need a positive action that's the data subject will take in order to manifest his or her consent. So that's something quite important as well.
Yes, and maybe as a last point, obviously you're going to, well, if you would rely on consent, you're dealing with very sensitive data. So it even has to be made explicit. Now, it's not really defined in the GDPR what is to be considered explicit. But I think that the Working Party 29 hinted at, for example, you could send an email, or you could, but it has to be something more indeed than perhaps just ticking a box, or, you know, as Pierre said, it really has to be an active action, let's say, of the citizen to consent.
Yeah, and I think if you read the guidelines from the Article 29 Working Party at the time, so for those of you not really familiar with that working party, which is now called the European Data Protection Board, that's the body issuing guidance about what you should or shouldn't do when it comes to complying with the regulation. So they've said, as regard to the explicit consent, that indeed they don't, I believe they don't really know what explicit means, but they tried to say that it's kind of a step more. So, right, for instance, you send an email and then you confirm again with a link in the email that you're consenting to the processing of your data. Or if you are, like having a physical meeting with somebody, you need to sign something, for instance, that would qualify as explicit consent. But yeah, to be honest, kind of unclear at the moment what the notion of explicit consent would mean.
Thank you so much for these answers. Speaking about special categories of data and explicit consent, which data more precisely do you think to fall under the scope of Article 9 and allow for explicit consent as a legal basis? What data more precisely should be regarded as perhaps health-related data in the context of tracing systems?
Well, I think that very straightforwardly, your status of being infected or not would qualify as health-related data. Every other, like your evolution, etc. I think almost all data that are going to be processed will be, well, you can infer some kind of health information of it. And maybe just to clarify that whenever you're processing sensitive personal data, so the special categories that are listed in Article 9, well, it's not really, you don't talk about a legal base as explicit consent. So you need your legal base in Article 6, as you do for all kind of processing activities. But then when you have sensitive personal data, the principle in the GDPR is actually that it is forbidden to process them. And then what Article 9 says is that, okay, the principle is that it is forbidden, but then you have a few exception grounds you can rely on. So it's not really so much as an extra legal base. It's more of like an exception that allows you to process it, even though it is principally forbidden.
Yeah, so it's kind of a double test, right? So you need to first have an exemption. And if you do have the exemption, you still need to rely on one of the lawful grounds listed by Article 6. But again, explicit consent here might not, so it can do the trick for the installation of the app, for instance, but it's, again, you do have other exemptions that could work better, and the European Data Protection Board has also emphasized that as well. You have, for instance, the notion of substantial public interest, listed in Article 9.2. You have the exemption also of public health. So those exemption to the prohibition of processing special categories of personal data could do the trick when it comes to the exemption. And that can be very easily paired with the legal obligation, for instance, or the public interest in Article 6. So again, explicit consent plays a role, but you do not really need it to basically justify the processing of personal data in the context of digital contact tracing. So that's also, I guess, some kind of a misconception. So consent's still very much important, but yeah, you do have other ways to do it. Yeah, and yeah, maybe on that as well, the fact that if you're going down that road, you're not free to operate as you wish, basically. So it's not because you're relying on one of the exemption or one of the lawful ground that you can do whatever you want. If you are to rely on, for instance, if you think about Article 6 and the lawful ground, if you want to rely on public interest, or if you want to rely on a legal obligation, of course, you will need the member state to adopt a specific legislation dealing with that, as we have seen in Belgium, for instance. So that law, of course, opens up scrutiny from the democratic process as well. So it needs to specify a lot of things, such as who is basically the controller, how long the data will be stored, for instance, or what kind of very specific data set will need to be collected. So everything needs to be basically written in the law. So that's kind of an extra guarantee. It's not because you rely on lawful ground in the regulation that you can do whatever you want. It needs to be paired, those two, not the other ones, but those two, public interest and legal obligation, needs to be paired with a law, a national legislation basically dealing with all those conditions. So yeah, it's kind of opening up scrutiny from the judicial as well in the country you were talking about, for instance.
Okay. So the next question is, what would happen if the data subject decides to withdraw their consent in this context?
Yeah, so withdrawal of consent again. So the place of consent needs to be rethought as well. So in cases where you do rely on consent, of course, you also have the faculty to withdraw that consent. That's a prerogative that is offered to any data subject in the regulation. And if you do so, it will not affect the lawfulness of the processing which have happened before the data subject has withdrawn the consent. Otherwise, that would kind of be very difficult for controllers to accommodate. So it will not invalidate those processing that have happened before. It will prevent the controller from relying on that lawful ground for future processing operation, of course. And it also paves the way for data subject, if there is no other lawful ground that can justify the processing, to request, for instance, the erasure of the personal data. So I guess if you decided all of a sudden to, we thought about this research, for instance, use for data. If you consented to the use of your tracing data to help researcher have a better understanding of where the pandemic is basically circulating, etc., which you could. I'm not sure that possibility is still live with the various app at the EU level, but you could at some point decide to opt in to those extra research features. If all of a sudden you decide not to, well, there will basically not be like the processing happening before will remain valid, but for the rest of the time, they won't be able to process your data for that very specific purpose, for the research purpose. And you could also try to request the erasure of the previous data, because that's kind of withdrawing of consent is kind of the first step towards erasure that you might try to undertake at the end. So I would say those are the main consequences. Maybe definitely want to ask something as well.
I don't really have anything to add on how withdrawal of consent would work. I think you did a good job yet. But then again, I think it might be useful to say that, since the beginning, we've been saying that consent is probably not the right legal basis, but that doesn't mean that even if they wouldn't ask for your consent as a legal basis, that you could not oppose to any future processing. So the GDPR also gives a possibility to object to processing and further processing, which kind of has the same mechanics. So in that sense, it's not a big issue, I would say, from a privacy perspective, that they would not ask for your consent as a legal base. And that might sound frightening, because if I don't have to give my consent, well, then how can I withdraw it? But again, you have another possibility to object to any processing.
Okay.
Thank you so much for your answers. Moving on to the second part of our discussion, I would like to introduce the next topic of our interview, which is anonymization. And I would like to ask what would be the meaning of the anonymization in this context of tracing systems?
Yeah, I might give you the first shot then. So anonymization is so first of all, a disclaimer, so Daphne and myself are lawyers, and when you're talking anonymization, basically it requires a lot, and really, trust me, a lot of technical expertise to even make it to the starting line to understand what anonymization truly means from a technical perspective. And I personally have been working a lot with computer scientists, and trust me on that, we do not share the same notion of anonymization when it comes to a legal conception or a technical notion. So that's really the first disclaimer more than anything else. We'll discuss the notion of anonymization here from a legal perspective only, because to be honest, we don't have the expertise here and now to do so from a technical perspective. if you're looking at the notion of anonymization from a legal perspective, so if you're looking at the definition of what personal data is, it's any information relating to an identified or identifiable natural person. So when you take that third block, identified or identifiable natural person, it also contains somehow the notion of anonymization within. So there is no definition of anonymization within the regulation, but you can deduce that from the notion of personal data. So the very tricky part in the definition of personal data is this relating to an identifiable natural person, because it's kind of difficult. So the threshold of whether or not a piece of data relates to an identifiable, so something that is possible to do, a natural person is kind of the difficult factor here. In order to assess whether or not a person could be re-identified from other sources, like a combination of different data sets, for instance, you need to take into account, and that gets a bit tricky, all the means reasonably likely to be used by the controller or even another party to do so. And this, in turn, needs to be interpreted through basically the context, technological context, the political context, the legal context. So basically, it's a very dynamic notion. You cannot really say, to illustrate a data set that is anonymized today might not be anonymized properly tomorrow, because there might be an extra data set out there that, in combination with the information you already have, might actually lead to the re-identification of a natural person. So the notion of anonymization, a data set that is anonymized, is a data set basically with no possibility at all to re-identify the natural person that is basically like the information relates to, for instance. And that's something that's really difficult to assess. So you had a lot of debates in legal and technical literature about that notion of anonymization, and even the Article 29 Working Party at the time acknowledged the fact that true proper anonymization within the meaning of the regulation is extremely hard to attain. So it's a really high threshold, and yeah, well, you might really struggle to attain proper anonymization. So yeah, you had case law as well from the Court of Justice of the European Union. So if you want a quite easy to understand example, you have the Breyer case law. In the Breyer case law, the Court of Justice basically said that a dynamic IP address was actually a piece of personal data, for the very reason that a person could ask the internet service provider to basically put a name on a dynamic IP address. So even though the IP address was changing over time, the information to link that piece of information to an individual was basically held by the internet service provider. And since, for instance, law enforcement agency could reach to internet service providers in order to ask for that extra piece of information, well, the court decided to say that, yeah, well, in that case, the dynamic IP address was basically a piece of personal data. So that's this idea of whether or not you can at some point try to put that name back to that piece of information, which of course is very context sensitive. So it's a really dynamic notion, to be honest. A lot of things to add. So it's a very complex topic, to be honest. So definitely might have something to say about it as well.
Yeah, as you say, it's a really difficult one, but I think it's clear that it's really not easy to anonymize. And you know what it means in this context, obviously, is that since there is such a high threshold to be able to say that, okay, some data set is truly anonymous, well, that it just means that the GDPR comes into play. So I think that essentially, if you want to make a contact tracing app, you're not going to be able to completely do it anonymous, and then it just means that, you know, GDPR comes, you have all these rights, you have all these principles you have to abide by. So I think that practically that's what it really entails.
And how should these shortcomings of the anonymization techniques at the moment be addressed in the context of contact tracing apps? For example, what would be the consequences of not being able to fully anonymize the data?
Yeah.
Well, I think I don't know, Pierre, if you want to start off, but I think that basically, if your data set is not anonymous, well, then it's personal data, and if you process it, so by automatic means, or even just make a file. So it means that even if you would have manual contact tracing app and you would not use any kind of computer to do so, which I think is very unlikely, but even in that case, GDPR comes into play. And what does it mean? Well, you have to limit yourself to what is strictly necessary. You need a legal base. You need all to comply to all these obligations. So what does it mean that it's not possible or that there are shortcomings? technically. I think that there's a big idea of, okay, GDPR applies, so yeah, basically I have an issue, but it doesn't necessarily have to mean that, you know, you have this big issue. You can certainly try to navigate in between them. So in that sense, what shortcomings, I think you should always aim to go as far as possible, that you can anonymize and make it as difficult possibly to be able to retrieve someone's identity. I think that is basically the goal, and that's kind of the whole idea of the GDPR. I don't know if you want to add something on that, Pierre.
No, indeed, I think, yeah, it's clear. So as Daphne said, people mainly think that if you are falling within scope of application of the regulation, you cannot do anything with the data sets. So that's kind of in the same level of misconception as consent as being the golden ticket for GDPR compliance. It's not because you're falling within the scope of application of the regulation that you cannot do anything with the data. So it's not a black or white situation in which either you fully anonymize the data set and then you don't fall within the scope of application of the regulation and you can do anything with the data, or you do not anonymize properly and then you will fall within the scope of application of the regulation, and as a consequence you won't be able to do anything meaningful with the data. Like, that's kind of the two extremes, but in between you really have a lot of basically complying with the regulation is fairly possible. I mean, I know people have been thinking that it's extremely difficult, and to be honest, it is. Otherwise, we wouldn't do some extensive research on it as well. But it's not that you cannot do anything with the data. There are some possibilities, and if you comply with the general principles governing the processing of personal data, so as Daphne said, mainly purpose limitation, so lawfulness, having a lawful ground, purpose limitation, so specifying a purpose and only using for compatible purposes afterwards, data minimization, so do not collect data that is not strictly necessary to achieve the purposes that you want to achieve. So those general principles are there as kind of pointers as well. So you have other kind of obligation, but the general principles here are the most important ones. So there's this whole lot of in between those two extremes. So it's not like you are doomed and you cannot do anything with the data sets that you're collecting if you do not properly anonymize. And in fact, not most of the time, but sometimes anonymizing a data set will also mean that you will deprive it from its utility. So at some point, and if you talk with researchers on that, and I'm mainly thinking epidemiologists, for instance, they might need to have some more precise data. Otherwise, to be honest, the value that you can extract from the data set is fairly limited. Also very apparent when you discuss with people in research. They really want some data, and if you tell them, look, stripe